Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I was out of town seeing a friend yesterday, so I missed a lot of stuff apparently that came onto the docket in Justin Baldoni versus Blake Lively. I actually saw a lot of stuff pop up really late last night or early this morning, depending on where you're at. And this is all about Perez Hilton's motion for a protective order, which he filed in the New York court, and then there's his motion to quash, which was filed in Nevada. I'm probably still going to be off camera for a little bit since I am out of town until probably Friday. All right, so he put in a notice of the motion to quash that was filed in Nevada. And in this document and his exhibits, he really did not hold back with the judge. I'll just read some of the more standout parts for you. Here he says, "It is my immense pleasure that this will be decided in Nevada and not in your court," speaking to Judge Lyman, "where, in my opinion, you have shown clear bias in favor of the defendant and have ruled in a manner that is shameful and of great concern for the public." And then he included in his exhibits some communications with the attorneys. Here he says, "Miss Hudson, it is my immense pleasure to inform you that I have just filed a motion to quash the legally unsound and unenforceable subpoena that you served me with on July 19th. I would also like to thank Mr. Gottlieb for bringing me up to Judge Lyman at the hearing yesterday. I am flattered that you all think I played such a pivotal part in the non-existent smear campaign you have accused Justin Baldoni and the Wayfarer parties of orchestrating against zero-time Oscar-nominated actress Blake Lively." And then we have another update here. "Hey cuties, just wanted to let you know that my motion to quash your unenforceable subpoena has been ingested, docketed, and updated. I'm super proud of you all and the millions you've been grifting from Ryan Reynolds' bank account. Keep up the mediocre work." Now, of course, Blake Lively and her attorneys have responded to this now. So they've filed an opposition to the motion for a protective order and a cross motion to compel with the New York court. And of course, some of this is redacted. And with the stuff that, comes in redacted, sealed, whatever with these guys, we know that they're intentionally misleading with that stuff. So I would be careful when interpreting what they're saying with this. As you know, they all implied that I was on some sort of tag list and that we met and conferred somehow, and none of those things happened. So I would be very careful with that. You can't just take these people's word for it at this point. They can use creative wording all day long in the court until they're blue in the face. Sometimes what you can get away with doing in court doesn't necessarily mean you're doing the right thing, and it doesn't mean it's not morally wrong or hurtful somehow. And that's why public opinion matters in these situations. The motion before the court concerns an individual who, according to defendants, the agency group TAG and Redacted, has seeded, generated, created, or influenced social media content or provided related digital or social media services directly or indirectly at the request of or on behalf of any Wayfarer party or their agents or affiliates. The specific individual who has acted at the request of or on behalf of the Wayfarer defendants is Perez Hilton, a social media personality who has described himself as the original influencer. Since August 2024, Mr. Hilton has created more than 500 pieces of video content about Miss Lively, almost entirely disparaging, and about the same number of posts of sensational headlines. Well, you don't really get to control what people say about your client if they feel negatively about her, and if a headline is sensational, that's not really your place to control either. He has declared Miss Lively's allegations of retaliation non-existent and labeled Miss Lively a bully who lies and is trying to silence Justin Baldoni. Okay, and your client's husband called Justin Baldoni a predator with absolutely no evidence to support that whatsoever. And your client and her husband were up in arms over Justin Baldoni having hurt feelings. And you're doing this? Mr. Hilton's videos are punctuated by name-calling Miss Lively, coining mocking terms for her, including Blackface Blake, Lying Lively, Ku Klux Khaleesi, and Litigious Lively. Do you want to explain why he gave her those nicknames? If not, then I wouldn't put this out there on the docket. Once again, you're just giving somebody the opportunity to explain in court why they don't like your client, and it has nothing to do with the litigation. Through his motion, Mr. Hilton seeks to preclude Miss Lively from learning which pieces of the avalanche of derogatory content described above was created at the request of or on behalf of the Wayfarer defendants. Although defendants TAG and Redacted have admitted that Mr. Hilton is among the content creators who worked at the Wayfarer defendants' request, and further admitted to communicating with content providers in writing via Redacted, Miss Lively has not received to date a single communication between Mr. Hilton and any of the Wayfarer defendants, or their agents, or anyone acting on their behalf. So again, this could be entirely misleading, just like it was when they kind of implied that 43 content creators were named on the list of tags, interrogatories, the people they disclosed in their interrogatories as having worked at their behest. And as we now know, one of 43 was actually on that list, and that person did a routine media request for comment. Whether or not you like that person or you personally consider them a journalist is irrelevant. He did not work at the behest of anyone, so that was a lie. So what they're writing here with these redactions can't be trusted. Here they're saying that Perez filed a motion in response to the subpoena seeking a protective order in the New York court that would require Blake to seek permission to serve any further third-party subpoenas. They say Mr. Hilton lacks standing for such relief, and even if he did not, has failed to provide any good cause to abrogate Ms. Lively's right to pursue discovery from non-parties. And as we know, everyone else who has asked for a protective order or something of the like, they were dismissed because the subpoenas were withdrawn immediately with no resistance after there was a motion to quash filed or attorneys met with them. And what they were actually seeking, apparently, just from what we know about what they asked people for in those meetings, and this was not me because they did not even meet and confer with me, what they were actually seeking was not at all what was asked for in the subpoenas. So it was transparently done in bad faith to harass and intimidate. And in this footnote here, the way they're characterizing what they've done is ridiculous. So they're saying the Wayfair defendants created a circumstance for a media firestorm over content creator discovery by designating their response as AEO, making it impossible for Ms. Lively to provide context for why she was subpoenaing Mr. Hilton and others. So she knows that there is a reason that that was designated AEO. The publicists have an interest in keeping their, contact list, their client list or whatever, private. They then moved to have that unsealed or removed from AEO designation because they knew it would make it look like there were content creators from the social media subpoenas who were on that list. And they expected Wayfair to fight that and to keep those designations attorney's eyes only, because that's, what would be in the interest of their client, the publicists. Wayfair then called their bluff. They said, fine, go ahead, unseal this information. And then Blake was left with egg on her face. But here they're trying to blame Wayfair for that somehow, even though they were the ones to take the first strike when they tried to get them to de-designate from AEO, and they filed that motion to pin this on content creators somehow, working at the behest of TAG, which never happened. They're saying that that was somehow Wayfair's fault, that they did that they bluffed. And they're saying this gave content creators with large platforms like Mr. Hilton weeks of fodder for outrage videos, claiming they were unfairly targeted and silenced by Ms. Lively, though clearly not silenced at all. Listen, if you are scaring people out of talking with those subpoenas, there is a reason for people to think you're trying to silence dissenting opinions, especially when you see the amount of distress it caused to people who are anonymous for a reason, and they have a right to anonymous free speech. Dragging those people into a federal court before a judge, either that or they lose their rights to privacy over their data and information, that's an abuse of the system and a violation of their First Amendment rights. It's only used to chill free speech. They received none of the information they were asking for in those subpoenas, yet they withdrew them almost immediately. Ms. Lively moved the court to de-designate the relevant discovery, which the Wayfair defendants did not resist, demonstrating that this may have been a media tactic from the onset. So once again, they're pretending that they are somehow the victims in this situation that they created. Wayfair made it very clear that they had to weigh the positives and negatives in the situation, and they decided that having that information released and absolving their client of this ridiculous accusation that Blake Lively is making was more important at that point. So she's using this to smear them. And so they decided, we don't want you pointing the finger at us like that anymore when you know it's not true. They released the information. And now she's using that to smear them somehow. And now Ms. Lively has had to move to compel the Wayfair defendants, who incredibly have not produced a single phone record, text message, email, or other written record of any communications with Mr. Hilton. Okay, again, a lot of the stuff that you're not receiving is because there aren't any. There are not any. I don't know if there were any communications between Perez and the publicist. I don't know. I'll have to go watch his video and see what he says about that. But in any case, there are many people from media and content creation who are reaching out for comment and making media requests. It does not mean they were working on behalf of anybody. This is grossly manipulative, and now it's completely see-through. All right, I'll go through a little more of this motion. I'm not going to read the whole thing. Since August 2024, Mr. Hilton, who identifies himself as an influencer, has posted more than 550 disparaging pieces of content about Ms. Lively. And they're just listing all his social media and shit like that. On his various platforms, Mr. Hilton does not hold himself out as operating as an independent journalist, nor does he purport to follow any of the tenets of independent journalism, such as, for example, diligently seeking subjects of news coverage to allow them to respond to criticism, or labeling advocacy and commentary. Well, Ezra, if he did seek you out for comment, would you even answer the email within a month? Because you don't even like to comply with meet and confer requirements. The majority of the content Mr. Hilton posts about Ms. Lively are disparaging, published without reaching out to Ms. Lively's representatives for comment or response, and generally regurgitate messaging that appears to be prepared by others. And once again, these people are just providing a document that basically outlines everything that the public has found wrong with Blake Lively and her conduct over the last several years. On June 25th, TAG served supplemental responses to the interrogatories, including identifying Mr. Hilton as one of 4 content creators who seeded, generated, created, or influenced social media content or provided related digital or social media services directly or indirectly at the request of or on behalf of any Wayfair party or their agents or affiliates. And as we know, this is not characterized accurately or truthfully. That interrogatory was broad and included anyone who reached out with a general media request or some kind of request for comment. And I'm not going to go over any more of the redacted stuff. I'm not going to go over the stuff that's, relating to it that's not redacted, because we all know that they are doing things in a dishonest way at this point. That is my opinion, based on what I've seen. On July 21st, Mr. Hilton emailed undersigned counsel stating that he intended to proceed pro se, notwithstanding the fact that Mr. Hilton is not indigent and the fact that he has previously claimed that he was represented by opposing counsel's lead attorney, Mr. Friedman. And the footnote here says Mr. Friedman represented Mr. Hilton in a 2008 lawsuit in connection with Mr. Hilton's alleged publication of a woman's name and email address. Hey, so what year is it, Ezra? Because my understanding was that we were almost 20 years in the future from that. And did he represent to you that Mr. Friedman was his attorney? And last I checked, you do not have to be indigent to proceed pro se. So the rest of this is really just explaining why they don't think that Perez should get the protective order. If you go to this docket on Court Listener, this is document number 567. I'm not going to go over the whole thing. And then, of course, they're asking the court to compel Mr. Hilton to respond to and produce materials responsive to the subpoena. They say he submitted to this court's jurisdiction by seeking affirmative relief, and accordingly, it's within the court's power to compel him to produce all materials responsive to the subpoena. All right, guys, that's all I got for now, but I'm going to try to keep up with everything as it comes out. Of course, I might be a little slower the next couple days because I'm still out of town, but I'll do the best I can. Thanks, and I'll see you soon.